And there are certain situations that warrant our separation. There are legal as well as illegal termination of the employment relationship. We want to look at situations that make termination legal and situations that make it illegal. And both have their consequences and their implications. Legal termination has its implications and requirements, and illegal termination also has its limitations and difficulties and other challenges. So we'll look at them. Good. Secondly, employment relationship or contract can be terminated by either party, either the employer or the worker. So let's go to our material that is from page 40, and see the situations. So according to section 15 of the Labor Act, Act 651/2003, these are the grounds upon which the contract of employment may be terminated. 1. By mutual agreement between the employer and the worker. The two parties can look at the situation and see what they are gaining or what they are losing from the relationship and the direction of the relationship, and agree that, okay, looking at this, we just need to bring this relationship to an end. So mutually they can agree at any given time to terminate the employment. Then the worker can also terminate the employment on the grounds of ill treatment or sexual harassment. If the employer is ill treating or sexually harassing the worker can stand on that and terminate the employment relationship. Ill treatment, that means the employer is not treating you, the worker, very well, and you think that this relationship is not helping me, it's not benefiting me, you can terminate it. Or if the employer is a male and is sexually harassing the worker, a female worker, that worker can decide to terminate the relationship. And it can be the other way around. Normally, when we talk of sexual harassment, we tend to limit it to only to women, men harassing women. But the opposite is also there, even though that one is not too common, is there. So once there is an element of sexual harassment, the affected person can decide to terminate the relationship, and this termination is deemed legal. Then the employment can be terminated by the employer on the death of the worker before the expiration of the period of employment. Let's say we have agreed that the person will work with us for 5 years or 10 years or forever, for long. Then unfortunate situation happen and the worker died before that period. The employer has every legal right to terminate the employment because the contract was made with a living person and to be executed with a living person. So the death of a worker automatically terminates the contract, and the employer must take the steps to formalize the termination or the end of the working relationship between the two parties. Okay, good. And we see this demonstrated practically, both the formal and the informal sector. You see that either before the funeral or at the funeral ground, workers, colleagues will come, they'll call the roll or they'll mark the attendance register, call the roll. Then people will be responding, present, present, present. Then when you get to the turn of the deceased person, there will be silence. Then at a point they'll say, oh, the person is absent. They'll ask why. Somebody should check what is happening. They'll say, oh, they'll go around it just as we normally do our tradition. We don't announce death immediately. We go around it. Yes, Rosemary, you are welcome. Good. We go around it small. Then finally someone declare that, oh, they had information that the person is dead. Then the leader of the group say, okay, now can we strike the person's name out of our register? Then they perform some rites. So even though we do these things customarily, it has a legal base to indicate that the contract between the employer and the worker is no more upon the death of the worker. Good. Then the employer can also terminate the employment if he finds that the worker is medically unfit to continue the employment relationship. If the worker is declared medically unfit for employment, then the employment can be terminated. However, a normal sickness that will take some days, weeks, or few months to recover and be able to resume work, you don't terminate. Let's get the difference clearly. If a worker is sick for some days, some weeks, even some months, and cannot attend to work, but medically there is every indication that the person will get well, recover, and resume, you don't terminate it. But if medical examination prove that the person cannot continue working, then you terminate it. In some organizations, they'll give you 1 year to attend to yourself, and you'll be on full pay for this 1 year period. If after 1 year the condition doesn't improve and the person cannot resume work, they'll give you another 6 months. Then they'll give you half pay, half of your salary. And if at the expiration of these 6 months too, still the condition doesn't improve, then the employer has a right to terminate the employment. There are some organizations that may not give you up to that 1 year, 1.5 years. But in any case, when there is a medical proof that you cannot continue working, the employer has a right to terminate the employment. Whatever the source and the cause of that illness is not a major matter. The issue is that medically you are unfit for employment. So that gives the employer a legal right to terminate. Good. Then the employer can also terminate the employment because of the inability of the worker to carry out his or her work due to we mentioned sickness or accident. Okay. Then incompetence of the worker. Then proven misconduct of the worker. So if the worker has a serious accident that incapacitates him and is not able to work, you can terminate. If the worker proves incompetent for the work for which you have employed him, then you can terminate. If the worker proves to be misconducting themselves on the job, proven gross misconduct, you can terminate. So these are the grounds on which the worker can be terminated or the contract of employment can be terminated. So there are cases here that we'll read for ourselves for details. These cases give us examples. We call it judicial precedent. So you can base, lawyers and judges base their cases on these decided cases to prove their point, whether termination is legal or illegal. Then there is this distinction we want to make between legal termination or illegal termination and wrongful termination. Okay. If somebody wants to come in, the person can come in with a point, with a question, or any addition. So when we talk of illegal termination, we mean the ground, the basis, the reason for the termination is what? Illegal, is not accepted. Okay.
Hello,
Hello, Ruby.
Rev, please, on the grounds of ill health,
Yes.
can the worker also resign on that basis?
Yes, there
That
was.
he's not feeling well with a medical report, and for that reason, he or she wants to resign.
Yes, it is also legal. The worker also has the same legal right to terminate the employment because of ill health. If he or she thinks that the situation may not permit them to continue working, they have a legal right to terminate.
Oh,
Okay, good.
thank you.
Right. So when the reasons, the basis for the termination is wrongful or is illegal, it's not the one that the law allows, we call it illegal termination. However, if maybe for some reason the ground cited for termination is legal, however, the procedure, the process of the termination is not followed very well, we call it wrongful termination. So you may be asked to differentiate between illegal termination and wrongful termination. So with wrongful termination means the conditions, the reasons are the one that the law uphold. However, the procedure, for example, they say if a case is made against somebody, you must give the person a fair hearing, constitute investigation committee, invite the person, listen to their side of the story before you take action. Then there's a case, let's say of misconduct. Then you didn't give the person a fair hearing, then you terminate. Your reason may be legal, however, the process may not be the right process, so we call it wrongful termination. Okay, that's the only difference between illegal and wrongful termination, and which we should take note of it. Okay, good. Then there is also the doctrine of notice. This doctrine of notice is simple and straightforward. It says that any party who wants to terminate the contract of employment must give notice to the other party before terminating. And if you think for certain reasons you should not and you cannot give notice, advance notice, then you must pay the other party in place of the notice. And normally, with a normal employment, full employment relationship, the notice is not less than 1 month. So you must give 1 month or more notice before you terminate. This notice is to enable the other person to make the necessary adjustments. Let's say the employee is terminating. This notice will give the employer the opportunity to look for replacement. I think within that 1 month, you can conduct some interview, select another replacement. So the notice is necessary. However, if you think that you may not be able to give notice, then you pay your employer 1 month's salary. 1 month of your salary you pay. The same way, if the employer wants to terminate and think that it doesn't need to give you notice, maybe the circumstance, if you give you notice, you may manipulate some situations, so they decide to terminate you without any notice. Then the employer is expected to pay you, the worker, 1 month salary as well. Very, very important. Then the issue of citing or giving reason. The law says that you can terminate without giving reason. Okay, that's the position of the law. You can just say, due to circumstances, blah blah blah, beyond my ability, beyond my control, I cannot continue to work with you. Therefore, I decide to terminate the contract. That's all. Then, where there is a need to make payment in lieu of notice, you make payment. However, from experience, I recommend, and most of us HR people recommend, that you state the reason. Okay, state the reason so that you cannot be misrepresented. Let's say that there is a gross misconduct and want to terminate, and you don't state the reason. The victim, especially if the victim is the worker can go and say, maybe you are harassing me, you are demanding something from me and I didn't agree, you asked me to do this, I didn't agree, that's why you terminate the contract. But if you state your reason, then the person cannot go ahead and say otherwise. Your letter of termination will show the reason. So even though by law you are not expected to or required mandatorily to give reason, we strongly recommend that you still give reason. Okay. And in business communication, when you are writing the termination letter, we cite cases that lead to, or situations, events, circumstances that lead to the decision for termination. If it is some offense, maybe your conditions of service, if at first offense we give you warning, verbal warning. Second offense or second occurrence, we give you written warning. Third occurrence, we terminate the employment. So you must give the instances of the first occurrence of the offense and the action that was taken, which is the verbal warning by immediate supervisor or the HR. Then the second occurrence, you must cite the date of the warning letter. Then on the third occurrence, you quote the various articles and sections. That's okay. Upon third occurrence of this offense, your contract is terminated. Very, very important. Okay, to give notice, even though not mandatory, but to us it's important to give reason. Okay, good. Anything on that, on the doctrine of notice and giving of reason?
Directly with the notice. Is it the employer who is supposed to give the reason or the employee?
The person who is terminating the employment, as we said.
So what if the employee is terminating on the grounds of getting another or a better offer? That person states that reason.
Oh, that is where I think you are safe. You are terminating. You are the worker. You are safe even if you don't give reason. So we will not demand that you give reason. And if you choose to give reason, fine. But that one, even if you don't give reason, nothing will affect you. Okay. And in most cases, they don't give the reason. You just give a notice. And yeah, I hope we get it clearly. If there's nothing too bad, you don't necessarily give the reason. But let's say if they were harassing you and you just terminate without giving reason, then maybe another day they say you embezzle the company's money. I hope you get the point. That's why you run away. It will be difficult for you to defend yourself at that situation. So in the first instance, while you are making your termination decision, indicate the reason. There are some circumstances too, maybe if the situation is quite embarrassing, okay, quite a shameful situation, you don't want to continue exposing the embarrassment to more people, then you keep the reason to yourself. So the circumstances will normally determine whether to give the reason or not. Yeah. You look at other psychological, emotional situations before you decide. Okay. Good. Right. Any other issue? So, if there's nothing, then let's go a step further. Upon termination, the employer, when the employer is terminating, he has certain responsibilities to discharge to the worker. The most important thing is any remuneration that the person earned before the termination, whether it is paid or not, you are supposed to pay it. The worker deserves it because he has worked for that period, so you must pay. Even if it is in arrears, you must pay. So any deferred payment, maybe per agreement, some payments are due but have not been paid. It has been deferred to future, you must pay. Then, if the termination is as a result of sickness or accident, then you must compensate the worker. The employer compensates the worker before terminating. Then, when there is a redundancy, we didn't look at the situations of termination yet, but we'll be looking at more. When there is redundancy and a category of workers are to be terminated, we prepare redundancy pay or redundancy package, and we must pay that as well. Okay, good. Then in terms of foreign expatriates who are working with us, this is where another difficulty arises. You must pay the person's expatriation fee, including the airfare, or simply put, the fare of the person and their dependents to get back home. It depends on the kind of contract or agreement you have with the people. But normally, when you are terminating the contract of foreign workers or expatriates, it involves a lot of cost, including their expatriate fee or fare to get them back to their home country. Okay, good. Then there's one other ground on which employer can terminate. We didn't mention that, redundancy. Redundancy, who can tell us what redundancy means in the first place? When we talk of redundancy, when we say somebody is redundant at work, what are we talking about? Xavier, can you share with us your understanding of redundancy? Yeah, okay, Ruby, you can come in.
Okay, let me cite an example.
Yeah.
For instance, in the production firm,
Yeah.
maybe let's say the sales has reduced, and for that matter, the number of products that the company is supposed to produce has also reduced.
Yeah.
Maybe they produce 1,000 in a month, and for some months or let's say a year, they are not able to produce 1,000 because sales have reduced. In that case, the number of staff that they have becomes more than the output that is being made. So with that, the company can decide
Okay.
Yes.
Okay. Very good. That's one. Where there is less work for the worker to do or no work for the worker to do for considerable length of time, that worker can be declared redundant. There are also seasonal situations. Some works are seasonal, and if the season is over, there is no work. Then there are circumstances where we introduce new method of production operations, new technology, and the person cannot adjust or adapt to the new. Then it means the person cannot continue to work. We are also closing down our operations, or there's a takeover of one organization. So the workers of the organization being taken over become redundant. So redundancy is a situation where the services of the worker are no longer needed by the employer. Where the services of the worker are no longer needed by the employer. It doesn't mean the worker has committed any offense or misconducted themselves, but just that the circumstances of operations make it so that there are no work for the worker. So the employer needs their services no more. So redundancy takes a whole process to administer, and in the course we'll be looking at redundancy management, or to administer redundancy. Okay, so this is one situation in which the employer can also terminate the employment. Okay, good. Now let's look at fair and unfair termination. Fair and unfair termination of employment. Good. Termination is fair if the contract of employment was terminated by the employer on any of the following. 1. Incompetence, as we stated already. Proven misconduct. Then redundancy or legal rescission imposed on the worker. If the law imposes some restrictions on the worker, let's say someone has been sentenced or convicted, maybe you don't have anything against the person, but some circumstances have convicted the person, and they say the person is under home arrest or house arrest. The person cannot go out to work. Then you can also terminate the employment. Or full imprisonment, incarceration. The person is taken off their home and cannot attend work. You can stand on that legal restriction and terminate the contract. Good. So these are the 4 main ways the employer can terminate: incompetence, proven misconduct, redundancy, legal restriction, plus other ones that we mentioned already. Accident that incapacitate the person beyond employability, or long and terminal sickness. Terminal sickness means there is no hope of recovery from that sickness. Then the employer can stand on that and terminate, and it will be fair. Okay. As I mentioned, if the reason cited is not backed by law, then it becomes unfair termination. So let's look at unfair termination. According to section 63, when you terminate on the following reasons, the termination becomes unfair: joining or intending to join, or causing or ceasing to be a member of a trade union. You cannot terminate a person's employment because the person has joined a trade union of their choice, or intended to join, or have ceased or withdrawn from a trade union. You, the employer, cannot stand on that and terminate it. If you do, it becomes illegal and unfair termination. Yeah. Then you cannot also terminate when the person is seeking office or having acted in the capacity of a workers' representative. That means someone is a union leader, then you decide to terminate their appointment because they are union leaders acting on behalf of a union. No, you cannot. Then when a worker files a complaint or participate in proceedings against the employer involving alleged violation of the Labor Act, you cannot terminate the employment because the person acted against your illegal activity. No, you cannot. If you do, it is unfair termination. Then you cannot also terminate on the grounds of what? Gender, race, color, ethnicity, religion, politics, etc. Just as we said earlier on, that you cannot discriminate against any worker in terms of employment or benefits on any of these norms: social status, religious affiliation, political affiliation, ethnicity. Once you cannot discriminate against them on these grounds, you can also not terminate the appointment on these grounds. Okay. Then we indicate that you cannot terminate a worker's appointment because of her pregnancy or absence of work during maternity leave. You have ILO Convention, International Labour Organization Convention, which Ghana has ratified. We call it Maternity Protection Convention. Under this Maternity Protection Convention, you cannot terminate or deny a person employment because he's pregnant. And you cannot terminate when the person is absent as a result of maternity leave. If anything, you can just have somebody to relieve the person for the period of the maternity leave. Then when the maternity leave is over, the person resumes. So you can engage a temporary worker in the absence of the pregnant woman or the breastfeeding woman who is on maternity leave. But I cannot terminate it. If you terminate, it becomes unfair. Okay, good. Then temporary illness or injury, where a medical doctor has certified that this person has a temporary illness or injury, you cannot terminate the contract. Then the law also says that the worker must obey lawful instructions of the employer. Obey lawful instructions of the employer. So if the employer gives you an instruction that is not lawful, you, the employer, cannot terminate it because he refused to take that instruction. Okay, good. And then if a person participates in a legal, lawful strike, you cannot terminate the employment. Okay, good. So these are some of the grounds for unfair termination by the law. Okay. Are we together? I hope we are all together. Okay, good. Then we want to look at the authority that terminates, or who writes the termination letter. Very, very important. It has a lot of legal implications. So at this point, I want somebody to read for us the one in the block or bold this thing. The termination of a worker must be done by an authorized person. Somebody should read that section for us, and the person should read louder. Who is going to do the reading for us? That's page 43. The third paragraph from bottom, page 43.
The termination of a worker must be done by an authorized person. in Moke versus Ghana Airways Corporation. The letter of dismissal of the plaintiff written by the personnel manager purporting to act for the managing director and the board was held to be illegal and void, since it was only the board that could dismiss the plaintiff. A subsequent ratification by a new board could not validate the act, which was void ab initio.
Yeah, very good. So we are saying that termination of a contract must be done by an authorized person. The general rule is that the head of the organization should terminate it. But internally, the conditions of service can mandate the HR manager or the HR director to do it on behalf of the head of the organization. But that must be clearly documented so that we know if your internal arrangement is that either the head of HR or the head of the organization, fine, then any of them can terminate. But if your internal articles and conditions say that only the head, then where there is the need for the HR to sign, must sign for and on behalf of the director or the CEO. If he sign in his own name just like that, it will be what? A wrongful termination. It will be what? Wrongful termination. The reason may be fair, but it may be what? Wrongful termination. And it has its implication. Okay. So only the authorized person. And if the conditions say only the head, then only the head. If for some reason another person should sign, then he should sign for and on behalf of. It means the person who is there has authorized you to do it. Okay. Are we together on that? So that follow the next article as well. Read the following one. Termination must be. Read the following paragraph.
Okay.
Yeah.
Termination must be in conformity with laid down procedures. In Abuaji versus Ghana Commercial Bank Limited, it was held that the defendant bank, which took disciplinary action against the plaintiff by invoking the procedures provided by the bank's disciplinary procedure rules, should have followed the said procedures in those rules and were bound to apply the rules of natural justice.
Yeah.
The bank's failure to give the plaintiff a hearing breached the Odi Alteram pattern rule.
Very good. So in this case, we said what? They must follow the procedure. So we gave an example earlier on, which also is cited here, that the person who is cited in a case must be given a fair hearing before a well-constituted investigation or disciplinary committee to accept or defend himself before a conclusion is made. Okay, good. Yeah, read the next case.
In Laguda versus Ghana Commercial Bank, the core idea implicit in the natural justice principle of Odi Alteram pattern was simply that a party ought to have reasonable notice of the case he has to meet and ought to be given the opportunity to make his statement and explanation of any question and answer any arguments put forward against it.
Yeah.
The principle does not require that there must be a formal trial of specific change akin to court proceedings. the principles are substantive rather than procedural.
Very good. So the principles of what? Justice, natural justice, indicate that you must give the person a fair hearing, opportunity to defend themselves, present their side of the issue. If you don't do that, then it means you've done wrong, and your termination can have serious implications on you. Okay. Now, if we terminate,
Initially, you said termination can be done without giving reason.
yes.
So in this case,
yeah, that's why I said that the law says what? You can do it without reason, but we strongly advise give reason. Are you getting it?
yes.
We strongly advise that give reason so that it cannot be misrepresented in future. So this is a typical example. The person was not given the opportunity to justify himself, and there was no what? Specific reason given them. So the person has a cause now to act against the employer's decision, which the court approved for him. So if the defendant, that's the bank, has actually given detailed reasons, give the person fair hearing, the person will not have had any ground to argue. So we look at how best to protect ourselves. All right. So if you terminate fairly, we know the conditions. One, you give notice, or you pay the person 1 month's salary in lieu of notice. If it is due to sickness or accident, then you compensate the person. If it is due to redundancy, you follow redundancy procedure, then you terminate the appointment and you pay the person redundancy pay. Okay. But in the case of unfair termination, there are three major remedies. Okay.